Mr. Downer. So when do you want us to...
Oh, yeah, but if you want to tell you.
Yes, please.
Oh, okay.
You want to
We've got our own, we don't
Yeah.
play
Yes.
Thank you very much.
Thank you very much.
He's not worried at this point. He said still.
Another?
May it please the court, my lord, I appear for the state in this matter, together with my colleagues Mr. Singh and Mr. Duploy.
Thank you, Mr. Downer.
As the court pleases, my lord, I appear for the first accused in this matter, together with my learned friends Mr. Masuku and Mr. Butelezi today, instructed by two senior attorneys.
Thank you, Mr. Mpofu.
As the court pleases.
Thank you, my lord. Mr. Jackson, I appear on behalf of the second accused, and maybe whilst on my feet, my lord, you would not necessarily note, but there is a different representative on behalf of Thales in the dock. We have a resolution, and the reason is that the previous representative is not available, and we did not want to cause any delay in this matter. I beg leave to hand up the with Mr. Downer and also with the other representatives. You would see that it makes provision also for a second representative, but just that's in case there's a problem when he's sick or whatever the situation is, can't be here for a day. The new representative, my lord, that you will see from the resolution is Mr. Olivier, and the pronunciation of the surname is it's Mr. Olivier Kuzerka.
Kuzerka, okay.
Kuzerka. And we ask the court to consider to then accept him as the new representative.
Yes. Shall we make this a further exhibit?
I think
we're down to exhibit E.
Exhibit F, your lordship's registrar told me exhibit F.
So this will be F.
F, yes, my lord.
Thank you.
Thank you, Madam.
Yes, the resolution passed by the Board of Directors of the second accused will be exhibit F. And I've taken note of the fact then the Kuzerka is present here today.
He is indeed, Madam.
Thank you. Thank you, Kuzerka. Thank you, Mr. Roo.
My lord, could I just say that that is in terms of section 3322B of the Criminal Procedure Act, and that if your lordship has regard to that, it's strictly speaking at the application of the prosecutor. Now, I absolutely have no problem with it at all, and so I formally make that application.
Thank you for pointing that out. Thank you. He is then so appointed as... Yes. The order of business, I think, Mr. Mpofu, you...
Be correct, my lord.
Yes.
Yes. My lord, if I may just start with a few housekeeping issues. Firstly, as we indicated to your lordship in chambers, your lordship will notice that the first accused is not in court. there was a medical emergency which took place in the past few hours, and we with the doctors, the situation is being attended to. I've now, since we spoke to you, my Lord, been assured that we might get some kind of document later in the day. But be that as it may, the proposal that we had discussed in chambers was the possibility of being able to proceed in the absence of the first accused. And obviously, as I indicated to your Lordship, I had to get instructions in that regard. I'm happy to announce, my Lord, that I have since received those instructions. And so we will be able, we'll monitor the medical situation, but, and I've personally spoken to the Surgeon General.
Surgeon.
Yes, so I kept on calling him the district surgeon earlier, but he's the Surgeon General. And and he has given me that assurance. The basis, of course, of the agreement was that is similar to the previous one that we had, my Lord. You will remember in September, where the accused had, although he was entitled to be present, for the sake of progress, agreed that we could argue the Section 106(1)H on the 21st and 22nd of September.
Yes.
Mr. Downer and I have identified the what we think is the correct section, which incidentally also deals with governments, but also deals with absence in general, as Section 159(2)A, Roman 1, my Lord.
Yes.
Yes.
Yes, as I understand it, he's instructed you that the application for an adjournment can proceed in his absence.
That's correct.
He waives his right to be present during those proceedings.
Yes.
And
Yes.
because in any
affidavit, my Lord. As I say, we're exactly in the same position we were in September last year, where practically it's an application, although we know it's in the criminal court. Yes. So that it's that same. Maybe Mr. Dana can confirm.
Yes, you confirm that, Mr. Dana?
I have no objection, my Lord.
Yes. Then that Mr. ZUMA is absent. He's not in personal attendance, and has agreed to the matter proceed. Say the application for postponement or an adjournment proceed.
That's correct. Right. My Lord, another housekeeping matter is that actually how we got to know all this is that last night we were supposed to be consulting with Mr. ZUMA, and he couldn't make it. And one of the was, of course, he would have signed the supplementary affidavit that would have reached your Lordship on Saturday. I've mentioned to Mr. Dunn to have therefore not been able to have that signed. The in it being referred to, if need be, the formality of filing a formal one would follow.
Yes, I don't, Mr. You confirm that?
Confirm that, my Lord.
Thank you. From our side, I don't have a problem with that. The unsigned copy that I had, or that I was given, referred to an annexure, being the cover sheet
the face,
of filing
yes.
the reconsideration application in Bloemfontein.
Yes,
I obviously do not have that, and if that can be handed up and I can see the date on it,
yes.
then I'm satisfied. Part of the factual matrix is also
It's
established.
done. Yes. My
I was
Lord,
told it's the 8th.
it is, my Lord. You can take it from me for now. We will generate that, but it's definitely stamped the 8th. It was delivered. It was filed here on the 7th and with the other side, but delivered in Bloemfontein on the 8th. And we will, your Lordship gets that copy.
Yes. Thank you.
Thank you, my Lord. My Lord, then, coming to the issue at hand, My Lord, this is a matter that really should not detain us for long. And I'll just what I think are the parameters, my Lord. I've got about parameters which I will use. Hopefully not use all of them. The first one relates to the matter that is pending before the President of the Supreme Court of Appeal under Section 17(2)(f) of the Superior Courts Act. That is referred to in the papers. Then, and that is the issue that we want to dwell a little bit on.
Yeah, that's the reconsideration application.
That's the reconsideration.
If we can refer to it as that. To me, Mr. Mpofu, that the factual matrix here is pretty much common cause. I gave a judgment dismissing the special plea. There was an application for leave to with certain adjunct procedures attached to it, which was dismissed in February 16th, if I remember correctly. And thereafter followed a petition, an application to the Supreme Court of Appeal to obtain the required leave where necessary in respect of my main judgment. And that was considered by two judges of the Supreme Court of Appeal and was refused, dismissed, I think was the term used, on the 18th, was it?
30th.
Sorry, the 30th.
It's 28th, but it's stamped the 30th.
Yes,
but
yes.
Nothing turns on.
But last week,
yes.
And then following on from that, an application for reconsideration, if I may term it that, in terms of Section 17(2)(f) of the Superior Courts Act, or pursuant to the provisions of the Superior Courts Act 10 of 2013, was then, as you indicated earlier, issued on the 8th, after having been issued or served here on the 7th of April 2022. And the issue really becomes one, without wanting to limit your submissions, as to whether this has a discretion, but to allow the appeal process to run its course.
That's correct.
And then I say the appeal process, i.e., that the President of the Supreme Court of Appeal must consider and reach a decision on this application, the reconsideration application. And that is the case that was made out, or the case initially made out in the application for an adjournment, was based on the petition still being pending.
Itself, yes.
That has now come and gone. It's been overtaken by events. But from the correspondence, which I was copied as well from Mr. Tusini, Mr. ZUMA's attorney, and the response of the state from Mr. Downer, it has been broadened to the extent that it now deals consideration application, which is common cause. It is there, it's in existence, and it's really the consequence that needs to, or that will flow from that.
That's correct. Yes.
And that will entail more specifically a consideration, amongst others, of Section 17 and it seems to me 18 of the Superior Courts Act. The initial application referred to Section 18 fairly obliquely, sort of just at the end. It wasn't the main thrust. Application for an adjournment, but it's certainly grown in stature in the heads of argument. And I think if we can focus our minds perhaps on that,
thank you, my
then,
Lord.
but as I say, without limiting you, but that seems to me to be the issue from having read the papers and having read the heads of argument.
Yes.
Refer to any specific allegations in the affidavits, well then obviously you're at liberty to